counsel. My name is Hugh Higgins, and I am counsel for Wieland Corporation, the petitioner in this matter. Wieland filed the petition for writ of certiorari to quash the trial court's order, which prohibited production of internal emails sent by the
Mr. Higgins, you're going to reserve rebuttal time? I'm sorry to interrupt, but.
Yes, please. 3 minutes. Thank you.
3 minutes? Okay, go ahead, sir.
Thank you. This petition is due to the court prohibiting production of Venetian internal emails sent by employees of the developer entity.
How many emails are we talking about? Because I sort of lost track. Initially, it was 200 and there was lots of documents involved, but I feel like it got down to a pretty small number, didn't it?
Yes, Your Honor. Initially, it was hundreds. Through the amended privilege log process, Venetian voluntarily turned hundreds over. And Wieland agreed to not seek a lot of emails if there was outside counsel on it. So we're down to a group of less than 50 documents at this point.
Okay.
And at appendix pages 60 through 78, there's a document titled Exhibit C.
Okay.
To our
and
petition.
they argued that these emails had to do with strategy conversations about their contract and if they took certain positions on it, and they asserted a privilege on that basis, as best I understand it. Go ahead, sir.
Yes, the gist is that Venetian is arguing that these were prepared in anticipation of litigation, and incorrectly states that the first emails Wieland is seeking are in the summer of 2017. There are actually some emails that are highlighted in blue that are in the October and November 2016 timeframe. And the contract was signed in October of 2016. So to think that there was anticipation of litigation all the way back in that timeframe, it just mind boggles Wieland.
But the trial court judge did an in-camera inspection and basically sustained their objection on this very limited batch of emails. You're here on a writ of cert, so you got to prove that the trial court departed from the essential requirements of the law. And it seems to me the trial court made a judgment call based on this in-camera inspection. So they did the inspection. It's hard to see a departure from the law. They did the inspection, they looked at the emails, they made a call, and that's an abuse of discretion standard, isn't it?
It would be an abuse of discretion.
So you got to show they departed from the essential requirements of law, which means it's not just legal error, it's got to be egregious, serious legal error. And this is an abuse of discretion standard, looking at emails of less than 50 and a huge batch of documents have been explained, and you've argued that is a departure from the essential requirements of the law. Why don't you focus on that first? How can it doesn't seem like that can be?
Yes, Your Honor. First, there's only two categories of documents that Wieland is seeking on appeal. First, there are documents that Venetian claims are duplicates of documents presumably previously produced in litigation, but for some reason doesn't agree to produce them now. We're at a loss as to why any duplicates of previously produced documents wouldn't simply be turned over at this point.
You've argued they've waived the privilege by virtue of that, right?
Right. To the extent a document was previously produced and is now being withheld as duplicate, that's waived. It should be produced. If there's some other situation, then we can address that. It wasn't made clear in the order. The order found documents were duplicative, documents were not relevant, and documents were privileged. And there was no explanation as to which were duplicative, which were irrelevant, and which were actually privileged.
So the court, in sustaining their objections, didn't make it clear it was doing it on privilege?
It did not. There was multiple conjunctions used. So the wording of the order is that if the court finds that those plaintiff has claimed to be duplicative in nature and/or previously produced as a result of chain emails are as such, period. Further, any objections asserted to the documents in their entirety based upon privilege or relevance is with merit and are hereby sustained. This is found at appendix page.
Well, your basic complaint is the court doesn't give a rationale for its holding, a specific rationale, correct? We don't know why the judge did exactly what she did, except for the vagueness of the order. So
That's
if you
one of
had,
the issues. Yes.
and if you had questions as to why, Judge, what are you doing here and why, giving specifics, were you required to file a motion for rehearing? And if you did, what happened?
We don't believe we were required to file a motion for rehearing. We didn't. We sought a timely appeal.
Okay, so you're filing a timely appeal based upon the order that might have been clarified, might not have. So you take the order the way it is, and you expect us to be clairvoyant to say the judge had improper motives. You know, the order on appeal is presumed to be correct. So we have a duty to sustain the trial, judge, unless you carry your burden to show error. So what is the error with a vague order? Do we defer to the judge? There's no requirement the judge give a better order than she did, that I know of. It's just a vague order. And when it's vague, it goes to the judge's benefit.
To be clear, that's not our only position.
No, I understand that, but keep going. Give me some more.
Right. So withholding of documents based on relevance grounds, as we've pointed out in the brief, is an improper basis. We haven't seen the email, so we can't possibly understand how an email about the Venetian project generated during the Venetian project could be irrelevant to the case when this construction case has literally issues coming out of the seams. But that was one of the grounds for not producing emails. The Giacalone case makes clear that relevance is not the be-all end-all. If it's likely to lead to the discovery of admissible evidence, it shouldn't be prohibited. And there's no way to cure the impact that withholding a potentially important document could have on the fact finder's ultimate decision in the case. We'll never know which document actually would have tipped the scales because we don't have access to it. We don't have the ability to develop further information on it. And the concept that there could be work product generated in the same month as the contract was executed, even though Venetian contends.
Well, I heard you say that the first time, and I mean, at the time the contract's executed, they probably had legal counsel talking to them about the contract, probably had them involved in the preparation of the contract, or at least consulting with them. And I can imagine emails that basically said, you got this provision, this is what's going to happen if that doesn't work out. I can see them getting legal advice at that stage of potential litigation. Everybody knows these big construction projects frequently lead to litigation. I mean, that's not a big surprise. So I'm not necessarily going to say that there's no way they would have had some privileged conversations on the front end at the execution. I mean, I can actually see more likely that there would be.
And keep in mind, Your Honor, these are communications that are internal to the Venetian team only. We've excluded from our request any communications that went to outside legal counsel. These are just,
even so, I can still see them having these conversations on the front end. I mean, these big, complicated construction projects are fraught with controversy. I think, you obviously do this kind of work. You know what I'm saying is true.
they certainly do end up in litigation frequently. I won't deny that. The manner in which hundreds of emails were withheld through a vague privilege log and then eventually giving more information. Initially, they were labeled as, quote, attorney work product, and then it was changed to simply work product. Whelan has a particularly difficult time with this adversary changing the terms of.
Well, show us how this court abused its discretion and basically viewing these less than 50 emails as, not to be disclosed.
If
I mean,
these
be
emails,
specific about that. Yeah, I mean, how did the court abuse its discretion in exercising the decision not to order the production of these less than 50 emails, which is what we're talking about here?
if the internal emails are not work product privileged.
Well, how
and
do you
they've
know
been-
that?
I don't have the benefit of knowing that.
Well, that's the thing. I mean, it'd be one thing if the court didn't conduct an in-camera inspection and said, hey, I'm not going to make them produce them. But the court did conduct an in-camera inspection and made a judgment call, which is subject to an abuse of discretion standard. And all you can do is theorize that the court made a ruling that they were privileged when in fact they weren't. You don't know that. We don't know that. Right?
I based on how we've been shielded from the actual information, I can't disagree with that, Your Honor.
Okay.
We can
So-
only say that
Yeah.
that.
I mean, that just creates a problem for you because the search standard is so high and so difficult to meet. You got to show it's a departure from the essential requirements of the law. And you've pretty much told me yourself, you're really not able to do that. You think that might have happened, but you don't know that.
We just can't imagine a circumstance where Venetian was already contemplating suing Wieland after signing the contract or in the month following. That we would hope for better than that.
Yeah.
Well, counsel, let me follow up a question that Judge Volante argued about showing. In preparing for today's oral argument, there's a recent, I think it is a 5th District case involving Public Supermarkets versus Molina, came out in April. And there is a passage in there that says irreparable harm is jurisdictional and must be found before a court may even consider whether there has been a departure from the essential requirements of law. And here's where it kind of triggers what Judge Volante said. Only if the petition demonstrates clearly that the appellate court has jurisdiction by virtue of irreparable harm not correctable on plenary appeal will the court move on to the question of whether there's a departure. And as you pointed out in response to your questions, you haven't seen them. There's no non-disclosure orders or something. So how do you meet that standard of showing us that there's been a clear departure? I mean, a jurisdictional thing here before you move on to a clear departure. My concern is that, this may have to wait for plenary appeal.
And perhaps the court needs to have the benefit of being able to review the documents in camera to be able to make that assessment, because we don't have the benefit of
Well, the
records.
trial court here did it, and had the trial court not done an in-camera inspection, may have changed the procedure, because there's cases that exist where the trial court fails to do that and cert is granted. But this is a denial from cert, and those are a little bit more difficult to get here in terms of certiorari, as Judge Morse is pointing out in the opening. And I thought that passage kind of illuminates, or at least places a context for our analysis here. Now granted, rehearing is not over in that case, according to my photocopy that I printed up here, but it did, kind of put things forward.
And in the Molina case, in fairness, that dealt with discovery requests to a third party, the actual
Certainly.
financial bias discovery of a healthcare provider. So that was in the realm of being more of a side issue, as opposed to here we're dealing with communications prepared by the plaintiff.
So your argument is that this brings you within the language of that passage about clearly demonstrable for jurisdiction purposes. Irreparable harm must be found before a court may even consider whether there's been a departure. And so you're saying that you have demonstrated that we have jurisdiction because the harm is not correctable on appeal when we don't even know what they are? I'm kind of concerned that in the lack of what we have, as Judge Volante was exploring for purposes of cert, and the nature of the relief being not automatic, has it left you in a very difficult position to establish the jurisdictional requirements Whereas perhaps on a direct appeal, you can ask the court to put it under seal, or you can see to make your argument of what it might lead to or other things. We don't know what it is either, so it kind of impacts us as well, doesn't it?
Procedurally, yes, and I in the ideal circumstances, the court would have before it the records have been withheld to be able to analyze whether there was abuse of discretion. So if the
I
court
appreciate you dealing with me because as I've told the other judges, I always have a unique problem when I'm dealing with cert because I want to treat it as a direct appeal and get to the merits. Maybe it's my days as an old trial judge. Let's solve the problem. But I have to give due deference to what the appellate law says about jurisdiction, and that's why I wanted to get your take on this.
And if the court has the power to compel those documents for purposes of the petition review, then that would enable the court to assess its jurisdictional position.
Thank you for bearing with me. I'll let you get back to your argument. I know you've only got 3 minutes reserved, and I don't want to take up all of this.
Yeah, you've got 1 minute of your time that you didn't reserve. So you're at 16 minutes right now.
Okay. I'll defer the remainder of my time to rebuttal. Thank you.
Well, you only, okay, that's fine. You'll get 4 minutes then, okay?
Thank you.
All right. Ms. Swing, it's your turn. Good
Thank you,
morning.
Your Honors. Good morning. May it please the court and counsel. I am counsel Morgan Swing. I'm counsel for the plaintiff, Venetian Multifamily LLC, which I'll be referring to as Venetian. Given the questions that Your Honor have asked, I can first state that I agree wholeheartedly that in this case, the court did hold a hearing, did have an inspection, and made a decision after an in-camera review, and agreed that this case and these documents, which were very limited, and I'll get to in a moment.
So Ms. Swing, does that mean in this posture, the case that this, in other cases in the same posture as this case, that we could never grant cert when a court has done an in-camera review and decided whether documents come in or don't come in? So we
I
can
don't think
never
we can.
second guess that?
No, and I would say that there are a couple of cases that have been cited in this case, the Giacalone case and the Bourne case, neither of which apply in this particular instance. In those cases, there would be the possibility for granting cert. In those cases, I'm not sure an in-camera inspection had occurred, but there are specific instances in which there would be no ability for the other side to be able to obtain documents that they need, either in the Bourne case to even get standing in the case, which they couldn't get, and that's why they were seeking those documents, or when there was no ability to go through specific set of healthcare requirements to show in the Giacalone case, and I may be mispronouncing it, I apologize, which is a second DCA case. There were specific requirements that to show the pricing problems with the hospital, and they needed those documents to be able to show it. So that might be an instance in which cert would be available, but that's not here in this case because—
Well, I'm troubled by this court's order that it basically is, prohibiting the disclosure of these documents based on the fact that they might have already been given, things like that. That's troublesome. I mean, I understand the privilege part. I can even understand the relevance, but on the basis that they've previously been given in a sea of documents, which is, it's not even fair to put that on opposing counsel, try to figure, okay, which in the sea of documents are these less than 50 are we talking about? I'm troubled by
and,
that.
and I can address that issue very briefly. What happened here, and I can explain the court's order right here, is this is very clear in the transcript that was set forth of that April 13th hearing. I was the one who argued the hearing. Mr. Higgins was not. His co-counsel, or actually his colleague, was the one who argued it. There were, of the many privilege log entries, there were many entries which were duplicative. That has become really a question, and then I think maybe there was a misunderstanding of what went on. And I will explain. This duplicative nature falls into two specific categories. Whelan is seeking documents here that consist of email chains, and so, which was set forth in the argument to the court. Many of these email chains were duplicative, meaning one, certain email chains included both work product privileged and non-privileged documents. So for example, maybe the bottom email was not privileged and had been previously produced to Wieland. But then the two emails on top of that in the chain were work product. Perhaps Wieland had sent an email to Venetian, and then Venetian internally had a discussion about that email. So the duplicative nature, or the documents that were already produced, were the document on the bottom, and the first email was produced, either that whole email chain with the two top ones redacted, or it had been produced in a separate email. And then the two top ones were the work product. So there were no documents that were privileged, that we're asserting the privilege on, that were otherwise produced. That's the issue where the court says, the court, having conducted an in-camera inspection and review of the documents, finds that those Venetian had claimed to be duplicative in nature and or previously produced as a result of email chains are such. So in the argument on April 13, I was the one who made the argument. I explained to the court that, one, some of these email chains of the 54 documents on the privilege log that were in blue that Wieland was looking for, some of those emails first were actually duplicative of one another, meaning, again, if you had an email chain, let's say there are 3 emails, one of the items on the log would be an email chain that had 2 of those emails. Then another one on the log would be that same email chain, but would have 3 emails. So that's the duplicative nature. So meaning of those 54 emails, you might have 4 of those 54, entries, you might have 3 of those that would be the same email chain. That's the duplicative nature. I explained that to the judge, and in the April 15th letter, which we included in our appendix, I went through in painstaking detail to show the court and made notations for the court to show which portions were privileged, which portions had already been produced, which were the non-privileged portion, and which ones were duplicative of one another, and that's set forth in the letter. So in fact, no documents that were privileged were actually produced.
So that leaves one question for me. The order that ultimately gets signed, is that something that the judge self-produced, or the parties had a say as to this is the order that we would provide, or how did that come about? Because it's a horribly vague order. I can see why it's confusing to the other side.
This was produced, this order was written by the judge herself after, I believe she received these documents. I sent them on the 15th. She received them by that Monday, and then she submitted this order, I think, the next day. So what she says, and she refers, I think, to the argument, and we have the transcript that says that she conducted the in-camera inspection and finds that those documents that Venetian has claimed to be duplicative in nature and or previously produced as a result of email chains are as such. To, I think, alleviate any concerns through her in-camera inspection that Wieland may have, that no privilege that when Venetian made the proffer to the court that certain documents were duplicative or certain documents were, a portion of them had been produced and were not privileged. And by the way, I noted on the document for her to show this is the Bates stamp number where that portion that was not privileged was previously produced. She's letting everyone know, yes, Venetian's proffer and statement in front of the open court is true. There's no other issue. So I think reading this order in conjunction with the transcript is helpful. Then she goes on to say, further, any objections asserted to the documents. So now we've set aside the duplicative, now we've set aside the privilege, just looking at the work product privilege documents, those objections asserted to the documents in their entirety based upon privilege or relevance is with merit and are hereby sustained. So you have to read them in separate issues. Really, there was that one issue going on to clarify any confusion, and she's saying, yes, we agree with the plaintiff in that instance, Venetian, and yes, now I've taken a look at the remainder of these documents, they are privileged, and we sustain the objection.
All right, thank you.
Okay. I'd like to quickly address something that Mr. Higgins had noted. He noted that, and this goes to the issue of actually finding up a privilege. He noted that there were many documents that came from the 2016 timeframe. And in fact, if you look at my letter, and you correspond, and I did this before, and I did this again, in preparation for this hearing, each one of these particular entries, the 54, which Wieland specifically was told by the judge that they needed to provide to counsel for the plaintiff of the particular entries with which they still took issue, for the plaintiff to produce those documents to the court. Plaintiff went through, provided those documents. Each one of those documents are documents from 2017, particularly starting around June 2017, right up and leading up to that period of mediation and the second addendum that is mentioned that occurred between the parties. And then afterwards, in 2018, after all of these issues about the scope of work, about the work product, about the type of work that was going on, the change orders and everything that's all part and parcel of, as Mr. Higgins put it, the issues coming out of the seams in this case, that's when everything started. So there are in fact no documents from 2016 that are left in here. And so the back and forth of the production, the back and forth of the emails between the parties when they were setting forth and putting together the contract, those have not been withheld, but for any attorney-client privilege documents, which Mr. Higgins has agreed that Wieland would not seek to produce. So in fact, there are no 2016 documents. And so any arguments that Wieland would make saying that they would not be able to get and support their fraud and the inducement claim, I think would be improper, to follow up on Your Honor's questioning. Once again, I do agree with Your Honor that there is a significant issue that Mr. Higgins needs to address with respect to the essential requirements of the law. And he has not met that departure because, again, this trial court has lived with this case from the inception. This is a case that's been going on for more than 3 years, has been set for trial, has almost gone to trial 3 times. We're on the 4th amended complaint. This is a situation in which Wieland has...
Is this relevant to the issue on appeal? I mean, I really don't want to hear the
Just to show that the
background.
trial... That's fine, Your Honor. I offer the background, but if it's not required,
Nobody asked.
I think the worry is we just want you to stay within the record.
That's fine, Your
Honor.
I'll go back to just briefly, as Mr. Higgins hasn't been able to touch on it yet. Each one of the arguments that that Wieland has made in their brief and their petition, we believe fall flat. As I've gone through the duplicates issue. I don't think that there was we don't believe that there was any waiver, as I've discussed in more detail. Again, Wieland makes a relevance argument. Relevance here is irrelevant if a document is privileged. And so relevance in and of itself is not going to cause an issue. Wieland is seeking and trying to get the whole universe of the documents. And I think it's very clear from the pleadings and also Mr. Higgins' argument that they're trying and they're scrambling to be able to try to find any particular documents, and they're unable to do so. It sounds like you don't have any questions on the privilege. I'm happy to discuss it, but can move forward if there are no issues or questions about the issue of whether or not there would be a privilege.
No questions from me.
Okay. I'll touch very briefly on the other issue about waiver. Wieland raises an issue about bad faith conduct and seeking an entire waiver. Again, as we've addressed in our papers, and I can rely mostly on our papers, this is an issue that's actually outside of the scope for this court, as these issues are not actually even part of the motion to overrule or for in-camera inspection. This is an issue that was part of a motion for sanctions that was previously held in front of the trial court. The trial court denied it, and it is not even part of the particular relief that is sought by Wieland on this particular narrow issue. And so we think that that issue, among other reasons, is improper, but certainly is not before the jurisdiction of this court. Once again, following up on Wieland's need for documents outweighs the privilege, I think that that issue is part and parcel of one of the questions you asked me before, in that, is there any circumstance in which the court could, grant a cert petition? And I discussed that there are circumstances, but they don't fall in this particular case, because all the cases that have been cited in this case relate to specific instances where the party who was looking for discovery could point to a specific item that they needed, be it a specific inspection report, specific information from a particular witness. Here, it appears to be that Wieland is looking simply for the universe of documents and is almost fishing for more documents and trying to eviscerate the work product privilege. And so in fact, we believe that the harm to Venetian would be greater by allowing the slippery slope and allowing work product privilege to be produced without such a significant showing. Thank you, Your Honors.
Thank you. Mr. Higgins, you have 4 minutes.
Thank you. I'll be very brief on rebuttal. I have 3 points. The first of which is Wieland is being asked to operate on trust. I've listened to the explanation, but the end of the story is Wieland is being asked to trust the process without knowing whether these documents are privileged, without knowing whether these documents don't meet the production standard on relevance. Second point is that
Doesn't that happen in any in-camera inspection?
and it does, and in some cases, an in-camera inspection occurs, the court gets it wrong, and a petition for writ is filed, as happened in the Boren case, which is 243 Southern 3rd 448. In that case, the court granted a motion for protective order precluding production. It was challenged, and the DCA stated that the court failed to make a finding of good cause and provided no explanation in its order as to why the protective order was granted to the scope that it was. And so we're asking for the same relief, even though an in-camera inspection was conducted. We're sitting on an order that doesn't provide a showing of good cause. And the last point that I have is that at appendix page 77, line items 842, 843, and 844, these are all part of the highlighted set that we produced to council in advance of the hearing. These documents have not been produced, and they're dated October 21st, 2016, October 21st, 2016, and November 4th, 2016, respectively. So without question, documents in the 2016 timeframe have been withheld. We're seeking those in addition to the others that we've requested, and we thank the court very much for its time.
Okay. Thank you both. These cert discovery cases are always challenging and difficult. You both did a nice job in your briefs, and your oral arguments were very helpful to us. So thank you. Have a good day.
Thank you.
Thank you.